We have now completed the constitutional method of review of statutory action. Now, executive action. But there are two more methods, that is known as statutory methods as well as equitable methods. So when we look at the statutory methods, the statute itself provides for a remedy. That is, the statute itself allows the victims or the persons whose rights have been violated to approach the court of law and get some sort of a relief in such cases. So, in each statute there is a method of approaching an adjudicatory authority as well as to appeal. The act of appeal is the case wherein you can go from that statutory authority to the High Court for review. So, for example, we have the Workmen's Compensation Act wherein they are saying that first you go to the statutory tribunal for any kind of a dispute resolution. But from the tribunal, you can approach the High Court regarding any point of law. So, if you believe that there is any kind of arbitrary action or the application of law itself was arbitrary in nature, then you can still appeal to the higher court for some kind of a remedy. Now, another kind of a statutory remedy is known as reference to High Court for statement of case, wherein sometimes the tribunals can reference the High Court for a statement so as to apply the correct point of law to the case. Now, in some cases, they are saying that especially under the Income Tax Act, where an application is made to the tribunal by the assessee and the tribunal refuses to state the case, the assessee may simply apply to the High Court, and if the High Court is not satisfied about the correctness of the decision of the tribunal, it can require the tribunal to state the case and refer it to court. So, there are cases in which the High Court itself can interfere and bring about the correct method or procedure to be applied in some cases. So, the statutory methods are known as statutory appeal, where you can appeal to the High Court or reference to the High Court for a statement of case. The third method is known as ordinary or equitable methods. So, under ordinary or equitable methods, we see three types of actions. The first one is known as an injunction, the second one is known as a declaratory action, and the third one is known as action for damages. What is an injunction? An injunction is also to be known as a stay order. A stay order is sometimes given in cases where an authority has not acted in proper methods, or to even restrain a person who's acting contrary to the law. So, it is a type of a preventive remedy that is given by the courts of law, and that is known as an injunction. The second one is known as a declaratory action, that is, where wrong has been done to a person by an administrative act, a declaratory judgment might be the appropriate remedy, in the sense that it may be taken as a judicial order issued by a court of law declaring the rights of parties without giving any further relief. So, in the sense that in declaratory decrees there is no punishment, or in the sense there is no kind of a sanction. Rather, it is only specifying the rights of persons, and it is going on to state that you have this right or you do not have this right. And this is what we call as an equitable remedy. The third one is known as action for damages. So, where there are any wrongful activities done by the government, then a person can actually file a suit for recovery of damages from the government. And what do we call as recovery of damages? It is known as monetary compensation. So, these are some ordinary or equitable methods that are available to persons in the sense of injunction, declaratory action as well as action for damages. We are now coming on to the principles of natural justice. Our principles of natural justice are derived from our constitution itself, and they go ahead to give two specific principles of natural justice. That is, your rule against bias, also to be read from the legal maxim, that is nemo judex in causa sua, in the sense that they are saying that a person must not be a judge in their own case. That is, a judge must not have any personal relationship with the matter at hand, and there must not be any real likelihood of bias, in the sense that there can be different relationships that might arise between the judge and the matter that he is dealing with. It might be a pecuniary bias, in the sense that there might be some financial interest which is related to the rulemaking matter. There can be a personal bias, in the sense that there might be some personal interaction between the judge and the person which might cause them to act in a biased manner. There can be subject matter bias, that is, subject matter bias can be something whereby the judge may be strongly opinionated about a certain principle or a certain subject matter. So, at that time, let us say for example, the judge is against the concept of deforestation or is a feminist, and if a matter related to that comes before him, then he is more likely to rule in favor of one person. There itself there is some kind of a bias. Okay. So, the principles of natural justice, the first rule is the rule against bias, followed under the principle of nemo judex in causa sua. The second principle of natural justice can be seen from audi alterum partem, that is the rule of fair hearing, or otherwise saying that no person should be condemned unheard. That is, every person should have a right to be heard, and every person should have a chance to explain himself. So, therefore, the rule of fair hearing goes on to say that no person shall be inconvenienced or condemned unless he is heard. And the principle of being heard goes ahead to encapsulate the following points. The first one is the right of notice. Only when notice is given we can say that the hearing properly starts. Then a person should have the right to present their case as well as evidence, whether this evidence is oral evidence or documentary evidence. Then the right to rebut adverse evidence. So, in the sense that there is a case of cross-examination wherein the witnesses are called by the opposite party for a cross-examination. This is to simply check if the witness is giving any kind of a false statement and to get to the truth of the matter. Legal representation. Every legal matter is very technical, and opposite parties must have, and everyone will have professional team of lawyers. So, if a person is illiterate or is unable to get adequate representation, then it would actually amount to a very grave injustice. And so, legal representation is also a principle of natural justice. Then we have the disclosure of evidence. So, every party must disclose every material that is relied upon for the purpose of his arguments before the court. Any material, whether reports, statements, documents, evidence, etc., must be disclosed to the opposite party. And then finally, we have speaking orders. That is, every decision of the judge must be given in its rational conclusion, in the sense that no judge can be given without proper reason, and only with that reason can we say that a judgment is proper. Now, if there is any absence of reason within the judgment can actually even be challenged. There are some exceptions to this principle of natural justice. That is, in some cases, the rule of fair hearing or even the rule of bias need not be observed. So, what are these exceptions to principles of natural justice? The first one is a statutory exclusion, in the sense that if the statute itself is silent, that is, if the statute specifies that there is no need to follow the principles of natural justice, then we can say that the principles of natural justice need not be followed. Okay, but they are saying that where a statute is silent as to the observance of the principles of natural justice, it always means that you have to actually follow it. Okay, that you cannot choose to exclude it from the applicability of of any section that you are applying. So, statutory exclusion says that wherein any law expressly excludes any requirement to follow natural justice, then we need not follow it. The second one is in the case of emergency. In the case of Maneka Gandhi versus Union of India, the court had seen that the passport of Maneka Gandhi was impounded without compliance of principles of natural justice. But then the court also observed that had her passport not been impounded, then it is likely that she would have left the country and we would have been unable to get her back to India. So therefore, the court gave an opportunity of being heard, that is, an opportunity of post-decisional hearing was given to Maneka Gandhi. So even though the opportunity of being heard was not given prior to the decision, it was given as a post-decisional hearing. Now this is only in the case of an emergency, that is, at that moment there was an immediate need to impound her passport, otherwise there is a chance that she would have left the country and not come back. The third one is known as interim disciplinary action. In Abhay Kumar versus K. Srinivasan, the order was passed by the college authority barring the students from entering the premises of the college and attending the class till the pendency of the criminal case against him for stabbing a student. Now the court held that the order was of an interim nature and not final, and it was merely preventative in nature. The objective was to maintain peace in the campus, and in this case the rules of principles of natural justice are not applicable, because please understand, interim disciplinary action is of a temporary nature usually, and therefore can be excluded from principles of natural justice. Academic evaluation. Academic evaluation is technically outside the scope of principles of natural justice, because the teacher who is teaching you will also be the examiner, the person who is correcting your papers, and they are entitled to give you the marks that is required to be given. You do not need to be given a chance to be heard for them to give a final decision. And lastly, we have impracticability. In Radhakrishnan versus Osmania University, the MBA entrance exam was cancelled on the ground of mass copying. Hence, it is not possible to give all the examinees an opportunity of being heard before the cancellation of examination. So, when it is considered impractical or impossible to follow, then we can actually say that principles of natural justice need not be followed.